Yeah, yeah.
Oh, thank you. That's not a chlorine.
That's why I don't drink it.
Yeah.
A bottle of fresh pop. I don't know, it's only same crap in it like this.
We've got a borehole and it's water straight from
We could leave it all on side.
And that's why he's got a better brain than I have, 'cause obviously drinking that's just full of... Yeah. It's fluoride, isn't it? What they put in poisonous fluoride, but they're killing brain cells with.
Can I check then that Your Honour has received a case summary, draft case management order and threshold document that I electronically filed yesterday? And Your Honour also received a CESA application from the local authority, which was filed by Manchester Solicitor yesterday afternoon.
Yes.
Seeking permission to build well, they're documents filed in the case, yeah. Its management of this case has been poor, especially from and there has been confusion caused by the local authorities for management of that, and I've set that at the outset.
Well, I think everybody will enforce, perhaps first and foremost, parents of children, those representing children, are entitled to explanation as to why the local authorities' management of the case has been poor.
Yes.
Futures of 3 children represented here, why has the case been managed poorly?
Yes, well, can I say in first response to that, Your Honour, that the Guardian in her position statement has invited the local authority to set out in full statement format the various steps of the local authorities' management and planning and what happened and what went wrong effectively, and the local authority will do that by 4 o'clock tomorrow, so there will be a written and signed statement setting out that by tomorrow afternoon. If it would assist the court for me to set out orally my understanding of those various steps and what went wrong, I am in a position to do that, albeit maybe not as fully as the written statement that will be tomorrow afternoon will.
Well, on one view that's appealing, on one view it isn't. My task is to ensure the right outcome for children.
Yes.
So why should I be deflected by having to apply my mind to poor practice on the part of the local authority? All I'm seeking is an explanation, perhaps in a few sentences.
Well, it's this, Your Honour. The social workers made their recommendations, which were approved by a service delivery manager, and set those out in a care plan. Procedurally, Leeds City Council now has a setup whereby all care plans must go to a permanency panel, which is comprised of heads of service, an IRO team manager, and other service delivery managers, and that permanency panel must approve care plans before they are disseminated. The first problem that arose in this case was that the permanency panel date in this case was after the date for the filing that's been set by the court for filing of the care plans. Those care plans were filed, the permanency panel then met, and the permanency panel did not approve those care plans as filed. So that is the first thing that went wrong internally within the local authority. The second thing that went wrong internally is that then in discussions both between my instructing solicitor and the instructing solicitor for father, and also separately between the social worker in the case and the father's advocate. The thinking of the permanency panel, which was around being separated from family and taking father was communicated, and that information should not be communicated in that way, so that caused confusion between the parents and the girls as to what the care plans were to be. So those are the two things which went wrong and will be spelled out in more detail. And as I've already said, the local authority accepts its fault in that.
Yes, well, so is the local authority regulations that require all these steps.
No,
Over the years, I've had a lot to say about it, but nothing seems to change. Why bureaucrats can't accept that the Children Act places the responsibility for approval or disapproval of care plans on the judge, nobody but the judge, I don't know.
yes.
It's the judge who hears all the evidence, hears everybody's point of view, and has the power to grant orders or refuse orders, sometimes refusing orders unless the local authority will negotiate with the court a sensible plan.
Yes.
So why we need all this bureaucracy of agency decision makers and permanency panels, I don't know. But there we are. I've expressed that view many times. Nothing changes. Thank you for the explanation you made. Now what about the children? Are we ready for the issue resolution hearing?
Well, Your Honour, no, because the care plans which I set out in case somebody would be filed at 3 o'clock yesterday afternoon were not. They have been now prepared and shared with the parties this morning. I have copies here. I apologise that I didn't arrange that these handed in.
Well, we'd better achieve something this morning, or otherwise I have to apply my mind to the question of whether Leeds pay the wasted costs of everything.
Well, Your Honour, the situation we're in is this. The care plans have now been filed. I'm told that by 4 o'clock tomorrow afternoon, and I've clear instructions on this, the local authority can also file both the statement that I've already referred to and also a social work statement setting out its reasons behind these care plans. So the local authority's case will be finalised by then. What hasn't happened, of course, is the parents being given any proper or fair opportunity to respond to these care plans.
Does everybody know what the plans now are?
Yes.
Right, well, let's start with the children and the plans for them. I've never copied it, but I've seen the names of the children and their chronological order. Which is the elder?
Stephanie, I believe, is the eldest child. Then Katie, Stephanie's age 14, Katie's age 13, and Harry's age 4 and 8 months.
They were in father's care, weren't they?
Until the 19th of September last year, when the police exercised their protective powers. Shortly thereafter, the children were placed in his mother's care.
So all three went to their mother,
Yes. And
at
have
some
been
point
there.
in crisis in their father.
Yes. And have been with the mother thereafter.
Do the parents accept that the threshold is crossed?
That, as I've also set out in the case summary, that is another failure on the part of the local authority. The threshold document was served yesterday afternoon, and the parents have had, whether it be father, really, who has to respond to that, but hasn't had an opportunity to
So
respond.
this is what I've got in my hand here, the first threshold document.
No. There was a,
So the parents have had notice at some point of how the court of case itself is going to consider time.
yes,
Something significant harm or likely.
yes, there was an interim threshold document in the bundle, and the parents,
Well, did that mean acceptance or rejection?
it was conceded. Yes, it was accepted. Yeah.
You know,
Is that concession still holding good?
Well, no, it's not.
For a final hearing, it's not.
Threshold isn't.
No.
And you're looking
Yeah.
There's no acceptance because the children and children who were subject to life substance harm.
No, okay. We have the, well, you very special to that, yes.
So the father is saying, I'm not empowered to make any public or law. Well, there's the first issue.
Yeah.
What about mother? Is it, this one, one of the-
Yes, the honour, the threshold doesn't go to mother at all, and mother has relied very much on the local authority's initial care plan, where it indicates that children cannot be sent to harm and need to remain in co-care, and that was the issue she was
Quite the
prepared
same
to
thing as addressing her mind for the threshold, is it?
It's not, but again, she's had to rely on information that she's had from the local authority and had seen no reason to.
Well, however she arrives at the decision, it is her decision that children
Yes, at the
were
time,
suffering significant harm.
yes,
Or the like.
at the time that the protective measures were taken.
She accepts the court is empowered to make a public law. Why? The father doesn't, so what do you say to father that says he's wrong about not accepting threshold?
I'm not sure what your honours advise me to
What,
say.
how do you say the threshold is crossed?
Because of the risk of emotional harm to all three children as a result of the acute psychotic episode that father did.
Likelihood?
Sorry,
Words
yes,
and
yes,
statute
yes,
are,
yes,
you have to prove a likelihood.
yes,
harm,
of
which
course,
is
I'm
always the
sorry.
same thing as risk.
No,
And a likelihood is only established on the basis of proven fact.
yes.
So what are the proven facts that establish a likelihood?
If your honours just,
Your piece.
yes, I'm just looking for the document. Yes, within the threshold document, I accept that I have used the wrong terminology in the headings there. So the proven facts with respect to emotional harm or likelihood of emotional harm that the local authority relies on are Mr. Howson's psychotic episode that he suffered in the summer of last year, his inability to care for the children at that time, his aggression and abusiveness towards social workers, including whilst the children were present during their inquiries. And then there's the particular incident on the 19th of September, which I know is disputed by Mr. Howson, where he was saying that he would kill the social worker and would take steps to ensure that him and the children stayed together forever, and wouldn't explain that further
All right.
to the social worker.
And those are the sorts of assertions the court will have to investigate.
Yeah.
And find the doesn't accept the threshold is crossed.
Yes, and then there's a separate issue, Your Honour, of the likelihood of sexual harm. The facts that the local authority relies on there are, first of all, I think this element is accepted by the father, that he doesn't have contact with his two elder sons because of his refusal to believe allegations they'd made against their paternal uncle of sexual abuse. And secondly, there were findings in proceedings against that same paternal uncle of unfailing to protect his son.
The children have alleged that the father's brother sexually abused them.
Older children not within these proceedings, now adults.
Sorry, they're older children of this father.
Yes.
And they've alleged against whom? An uncle.
An uncle, yes, this
Their
father's
father's
brother,
brother.
yes,
Right.
that he sexually abused them.
And this father doesn't.
He refused to believe
His own
that,
children's allegation.
yes, within private law proceedings, and his refusal to accept that led to him then having no contact with them. There is a finding in separate public law proceedings against that same uncle with respect to a failure to protect his son from the risk of
So of
sexual
course
harm.
it's decided in private law proceedings that this father, the best interest of his older children, should have contact with them
Yes,
because a risk was identified of this father bringing those children again into contact
yes,
with the
yes,
brother.
yes. The pertinent thing for these and the pertinent thing for these decisions is that this father has refused to discuss any risk of sexual harm to these children arising
Children
from,
aren't.
yes, arising from any contact with the wider paternal family
You're saying a
members.
finding has been made against this uncle.
Yes,
In public law proceedings.
yes. But it's in the bundle. Those proceedings were released into these and I've referenced that in the threshold document. So that is the separate area that the local authority points to, which would need to be litigated if disputed. So that's what the local authority says to the father in terms of threshold in answer to your last question.
Issues about pressure now. So what are the plans for Harry's nephew Katie?
The plans are for all three children to remain in the care of their mother, subject to supervision orders. The plan is for the girls to be allowed unsupervised contact with their father, but for Harry's contact for the time being to remain supervised as it has been by his mother. The local authority, and can I say, Your Honour, that I have not had an opportunity this morning to fully read the care plans. I've had them explained to me by the social worker, so I don't have a good grasp of the fine detail, but I understand they set out work that is proposed to be done with the girls and with Harry. Firstly, to move the girls to a situation where they might have overnight stay in contact with their father, and also so that Harry's contact might move to unsupervised contact. And the aspiration over the course of a 12-month supervision order is that certainly the girls, if not all three children, might move to effectively a shared care arrangement as between the father and the mother. What the local authority wants from the father in order to move towards that is the type of engagement that the local authority says has been lacking hitherto, to work with him around risks to the girls arising from maternal family members and so forth, as I've already outlined.
So, if we get this right, you're asserting against Mr. Howson that he is likely to be a cause of significant harm, any sexual harm to his children, because he doesn't accept the risk posed by his own brother.
Yeah.
And other children of his don't get to see him because the court has decided they are at risk and the father who doesn't accept them. But the uncle is at risk of sexual harm. I'm struggling therefore to see why you have a plan for these girls, Stephanie and Katie, receive their father unsupervised from the state.
The social worker's view is that the girls in particular have developed a high degree of resilience to some of the mental health issues. In terms of the risk of sexual harm, the social workers are confident that work has already been done and can continue to be done with them
Self-protection.
to protect themselves against that risk.
Harry? Is he not going for unsupervised contact?
Not for the
Your plan,
not for the time being within the local authority's care plans, no. But that is something that the local authority does look to work towards.
So is that difficulty going to be resolved within a year? The life, maximum life of the supervision order, subject to the power of the court to extend on application.
Well, I suppose anyone can say that it will be resolved within a year. It is the local authority's intention to try to achieve that, and of course there is the option, if it couldn't be achieved within a year, to renew a supervision order on 2 consecutive occasions. So there is significant scope to elongate the period of the local authority's involvement.
All right, well, that's enough for you. Thank you. What does the mother say about the, she acknowledges the court has the power to make a supervision order?
She does.
She accepts thresholds crossed.
She accepts thresholds crossed, and
Does she agree with how
Yes, I mean, to say she's been confused over the last 3 or 4 weeks is the understatement, because she has responded to the original care plan, which provided for them to remain in her care. And I have to say, part of her statement was some concern that local authorities were not going to continue to be involved with assistance in relation to
The early plan was just that she take a residence order or something.
Yes.
Sorry, child arrangement.
Yeah,
And
I think she was concerned that local authority might well walk away and leave her to it. And I haven't had the opportunity of talking to her about the care plan, but she literally just as we came in. I don't anticipate that she would be opposing the supervision order. The court felt that was the appropriate way forward. There are some very serious practical difficulties for this mother, though. She's currently living with the children in accommodation in the tenancy in Mr. Hanson's name. Mr. Hanson indicated that that's not the situation he can tolerate. She needs to find alternative accommodation, so we need some assistance there from the local authority. Relying, I think, on the original plans of the local authority and now their current plans, she has reduced from the 1st of March her hours at work. She's going to therefore have a significant reduction in her income. I'm afraid she sees the prospect that this case is going to progress longer than the timetable that we had originally had.
I'm not sure it is yet.
That it would give her serious concern, that's all I'd say. And in terms of responding to the care plan, there's little that we would need to do that we haven't already done. So I'd be able to respond to those plans.
Taking on board as I do the fact that the father doesn't even accept the court will have jurisdiction, make a supervision order. Beyond that, the arrangements for the 2 children. Family father's case is about the outcome of the children.
I've had an opportunity to take instructions in relation to this document that was provided this morning. The father's position throughout all of these proceedings, and I might have to confirm it, that he will seek the children to live with him on certain conditions. He wishes to return to his home.
Right. I just said right, which indicates I'm following what you're saying.
Sorry. He wishes to return back home. He would ideally like to see a strict resolution to this issue so that he can get back home and he's living temporarily in a caravan at the moment. His case has always been in relation to the threshold of this system, and I'm going back. I raised this for your to consider. He's never had a full picture of what the allegations against the 2 brothers are. The threshold that is referred to as a finding in relation to Carl, brother, was an agreed threshold. The plan was for the children not to live with Carl. There was a plan that the children should remain within.
Carl is your client's brother.
Yes, we've got Carl, Mark, and Andrew. Those are the 3 brothers. My chap's Andrew, and the 2 brothers are Carl and Mark. There are concerns about both.
Right.
Carl
has admitted something in public law proceedings.
In public law proceedings about himself. But in public law proceedings, he also accepts that Mark might be an issue. But those findings, it was 6. I think we're at about F27. Those findings were an agreed threshold. So when we're talking about the risk of...
Well, he was either admitting that he committed some sexual misbehaviour or he wasn't.
Not in relation to Mark, forgive me. This is what I'm saying. In relation to Carl, my client can reflect and take on board the concerns about Carl, because Carl's position in those proceedings is, if it was a third man, I dispute it, but if it was a third person, I can accept those risks. So that's Carl. So obviously, my client can reflect. In relation to Mark, Carl has said, I accept that there could be a risk in relation to Mark, but there were no findings made in relation to Mark. And my client's position has always been, he doesn't have a full picture of what the allegations in relation to
I'm
Mark
not
are.
understanding this. Carl, who is Andrew House's brother, has accepted that he poses a risk to somebody.
Yes.
But he can only have accepted that he poses a risk to someone by virtue of accepting what it is that provides the source of that risk. Do you know what he was accepting he had done? Indeed, he should be regarded as a risk to them.
It was
I wonder if it helps. Mr. Brown's threshold document, paragraph 7, sets out exactly what it was that these gentlemen accepted or didn't.
Carl was accepting that one of the children had seen sexual images when with his paternal uncle Mark. That's as I read that.
Yes, you're correct. But that was the issue. Mark never been tested on the issue. That was related to the threshold.
And I'm going to all this because, I've read somewhere that the final hearing, which I think is listed as at risk. So far, I've heard nothing. What's the final hearing at risk? Everyone can have their say in the witness box and I'll decide.
I've raised.
But
because
anyway, Father says the case should come through with restoration of the status quo as it was last summer. The children back with him.
Exactly.
And he would go back into the accommodation
And the children would
where
raise.
mother's currently living. The tenancy in his name.
Yeah, his hand.
Because mother moved into his house when she assumed care of the children. Right?
The picture presented by the local authority is that they have provided Father with a full picture of the allegations and what the foundations of those allegations were. Father has always had a problem accepting that he's got a full picture of what the allegations are so that he can reflect on those allegations. That's been his problem.
So is it a complaint that something should have been disclosed, it's not been disclosed?
Yeah. Potentially, these records in relation to Mark, these records in relation to Carl, so that he can see what the allegations actually are.
You say police records, you mean documents that were accumulated in a police investigation?
Yeah.
What police national confusion or conviction?
No, because my understanding it was.
Really wasn't.
No. And the problem, well, not the problem, but his concern in relation to what's been disclosed in relation to Carl, and that's F in the book, those legal proceedings, LJ 11, care proceedings. Vicky Gross is, I think, a social worker who does an awful lot of analysis, but again, the actual source, the primary piece of evidence that actually says this is something that is founded in fact, again, is missing. That is what fathers always have a problem with, seeing the fact.
Right.
Well, that is.
This issue may become quite secondary, at least, in the face of the other matters on the threshold. I mean, did Father suffer a decline in mental health last year?
He did, but Your Honour, I don't know whether you
I'm
have
not going to receive evidence as to how that may have impeded his ability to look after the children.
Well, you made reference, Your Honour, in relation to the permanency panel and all the bureaucracy, but one comment of the permanency panel, who are senior managers from all branches, there's no evidence that children would come to significant harm in dad's care, and the plans will be put in place so the girls would have plans to follow if they start to get concerned about dad's mental health. Again, there's more evidence about, at the time intervention was taken, Father had suffered from mental health issues, just moved forward to.
I should have asked Miss McNally whether she was ready for a final hearing, or all before she was indicating she is. Yes. Are you saying there's no way all the evidence can be properly settled? You can be ready for a final hearing a week on Monday?
We're still waiting for the analytical assessment from the social worker. We've only just got
Ms. Groves to assess what?
no from the social worker in this case. Ms. Groves was in the previous. We're still waiting for that analytical to forensically explore why the shift in position is so significant. We've taken preliminary instructions at the conference, but there is, in essence, a shift of position without, I would like, an awful lot intervening in the meantime.
You're awaiting a statement from the social worker explaining a shift in position.
Without any change in circumstances, so that we can respond in a substantive statement. And to do that,
Now, how significant is the change? Has there been a time when Leeds were saying the children should go back to farm?
well, the two girls, yes. I mean, the evidence in the final care plan says the girls are distressed. The issue's always been Harry, of course. And the separation of the siblings has perhaps perhaps caught it. I've not read any. But obviously that is going to be something we need to explore.
Well, you are certainly have time to see, read, digest, and construct a statement from the social worker explaining the change in the plan. Now, when's that happening? Mr. Brown,
4 o'clock tomorrow.
4 o'clock tomorrow?
Yes.
Right. That gives you more than a week to read, digest, and take instructions on. Doesn't it?
It does on that aspect, Your Honour.
Right. Well, what's the other potential of the evidence?
It's just note,
The disclosure of what, remind me?
Carl and Mark, and whether or not there was any investigation into it, we want to find. We don't know the provenance of these concerns. We just know that it's been assessed in previous proceedings.
Is the information likely to be used to file public court proceedings relating to Carl?
It's not. It is secondary evidence coming from Ms. Gross.
We did the assessment.
We did the assessment. We don't know where it's from. It could be anonymous referral. It could be, we do not know the provenance of it. There were, of course, allegations made by children, but we don't know to what degree they were explored. Maybe when we've got a conceded threshold, not a finding, there is a concern about the accuracy of that. So my invitation is that if we are, I mean, if I can,
I think I'm going to ask Mr. Brown now how material it is in his case
That's got fuck all to do with
establish what he sets out in paragraph 7 discretion.
police have done.
Material in this sense,
He's
Your
asked
Honour, the social workers have been and remain concerned about Mr. Howson's refusal really to discuss this issue at all
Just keep buying
in
it
any
along the field
meaningful
till
way, so
everything
it makes
far.
it very hard for them to gauge the level of, well, the extent to which he could be a protective factor for the children against these risks. The fact that the local authority relies upon is that this finding has been made in public law proceedings, with the consequence that neither of the paternal uncles nor the paternal grandmother has any unsupervised contact with the relevant child there. This father has refused to engage in discussions about that and the consequences for his children.
I call that mention not to be me and my mother lied about.
Really, that level of engagement that the social workers seek, which is material for them.
Do you know what Mr. Nixon is talking about, this assessment of undisclosed?
Well, I think that assessment is within this court bundle, and I believe it's in the F section.
Oh, right, Mr. Nixon, you've got it already?
yes, it's right in front of me. It's F58.
Yes. Well, can't this court decide whether your client is being appropriately protective of his own children or not on the material like that? It being a fact apparently was a finding as set out in paragraph 7. Seems to be really a debate about his attitude.
Well, yes.
Yes.
Yes, I've forgive me, I've looked
If
at,
you find a judge insisting against the protester, any party, but the case must go on even though that party seems to be feels it's not ready. That's of course what is to start, but if there comes a point when I agree with you, justice can't be done.
stop with it.
We'll stop. But my information is, I'm not hearing anything at the moment which precludes me from starting with it.
The concern my client has got is that the finding is predicated, well, one of the issue is we can't work with them because we can't face these issues. So one has it. My client's position is I've never seen anything in black and white that really tells us it's founded in fact. If there was something, and one would suspect there could be a police investigation related to, that is founded in my client would have an opportunity to reflect. The concern is that there could be a finding that he is failing to reflect because it could be seen that he is, on the basis that there is not something for which he can, excuse my terminology, but have faith that it's accurate.
And there is a fact. Under Carl, they would let this happen. This potential emotional harm. I have again. It's no. Uncle Carl was found to be culpable. And there's the finding.
This is going to be perhaps a very loose and discreet point. The limitation is an agreed threshold. It is a world apart from one where findings actually, well, evidence is tested. Well, because if a parent
Somebody
takes,
agrees something happened, it happened.
but no, forgive me, Your Honour. It is an agreement that a risk has arisen as a result of something happening. I'm looking at F28. F28 is what Carl is really saying about Mark.
What's it actually?
This is a threshold. In the previous proceedings, we're referring to its findings having been made.
It's in paragraph 7. It's a misrepresentation of what was agreed as fact. It goes to proceed.
Found. I'm taking issue with the word found. If one is glad no other plan that they're amenable to, then my invitation is, if anybody agrees with threshold, it is not necessarily something
And
that we
if
call
Uncle
fact.
Carl agreed in proceedings relating to his own children, that which is set out in paragraph 7, that is a finding. It was a finding which informed the outcome of those proceedings.
My
The
invitation,
judge was absolved from the responsibility of discovering the facts because the parents to be found. Any other points, Mr. Wilson?
the interim position, very mindful of this, Your Honour, the interim position. If the girl's plan is for unsupervised, why do you need to wait? Obviously, I've had that raised as an issue. The plan is for unsupervised, local authorities are duty to
Well, we're going to be waiting if I get my way, get the hearing up and running every topic.
But again, I appreciate we'll be waiting, but again, we've got 2 weeks between now and then, and if the plan is for unsupervised in any event, my invitation is, if the least interventionist, and we are still in the court proceedings and it's an interim, what is the jurisdiction for saying that supervision is the least interventionist when the plan is for unsupervised?
Was this controversial with any other party?
Yes, potentially. It's not something I discussed.
No, I'll definitely resolve this issue resolution for you. I think it's quite a few. Anything else, Mr. Kingston?
Just the application to withdraw, I think that's the only thing left on my list.
Withdraw.
Yes, the application, the C2 application, that right at the start, says local authority needs permission to withdraw it. I would simply, I would simply
I
say,
don't have ever seen an application by an authority to change its cap. There are far too many changes because planning seems to be very difficult in some cases. But
Why?
if we
the care plan there has to be before properly to scrutinise it. So if it changes, it changes.
my invitation is withdrawing terminology. I would invite that withdrawing is appropriate, but if it wanted to change its name to first care plan, the first final care plan, and the final one, final care plan.
I mean, the fact
so
that
long as
it
it's in the
chops and
budget.
changes its plans may be illuminating of the merits of the final plan. But I can't stop the local authority telling the court and telling you, as they must, that their plans have changed.
No, absolutely.
I don't think it needs applications to introduce.
It was the withdrawal I had concern with. I still want the 1 of January in the budget.
Of course,
Yeah.
every care plan should be fine. No problem with that.
Absolutely not, Your Honour.
One final thing I raised, just because it may become an issue, so that you're aware of it.
Yeah.
Jade, surname forgives me, Jade Lamb, social worker, led to, telephone conversation led to these powers of protection with consent. This is the statement you've just given, the statement taken previously. The content of that is disputed. I have it on firm instructions that a tape recording of that conversation was made. It was made with Ms. Lamb's knowledge, and it goes to the very issue of veracity.
So there's a telephone call between.
Sorry. There is a telephone call between Ms. Lamb and Dad.
Right.
That is contained.
It's not a social worker.
Social worker and Dad. That finds its way recorded in Ms. Lamb's original statement.
Right.
This statement. Dad takes issue with that, disputes that he threatened to kill her. There is actually a telephone.
Somebody was tape recording the conversation.
With both parties' knowledge.
Right.
Dad's going to make reference to what was actually stated in his statement. I simply raise now, for the purposes of admissibility, whether or not the court would like copies of that recording in the interest of having a
there's
full
a dispute between two parties to a conversation on the telephone as to what was said in that conversation. It's agreed fact that a tape recording of it. That must be one of the rare circumstances in which I'm prepared to listen to a tape recording. Is that right, Mr. Brown? There's a tape recording on it?
I have previous knowledge of that. I think the social worker's position is that they had been told by Mr. Howson on occasion that he taped everything, so they're not being taken by surprise at the proposition that this particular conversation was taped. What I'm not conceding at this stage is that there was a prior agreement by the social worker to this particular conversation being taped. However, if there is a recording of it, then clearly that is the best evidence of what was said within that conversation.
Does anybody object to Mr. Nixon introducing in father's evidence the tape recording of the telephone call?
He's entitled to produce, as part of his evidence, whatever he produces as an exhibit to it.
It might assist in the interest of brevity
Well,
mind.
it's part of your case, right? It is your client who is doing the taping. Yes, but if he wants to support his case by contemporaneous record, which is what a tape recording is, whatever is said, by all means.
Those instructing me have done a transcript already, so I've circulated the transcript for release, and if anybody wants to listen to the tape, it might be easy to get that.
Right.
Obviously, my solicitor.
They spare me the task of listening to it if the transcript is prepared, and all the applicants can listen to it and check it against the transcript. Right.
Might have sent them back very briefly.
Yeah.
Unsupervised, complete disclosure there. Transcripts. Private law. Private law. How long did you sure we're forgetting the private law? No private law. You sure? You sure?
Your Honour, on behalf of the Children's Guardian, myself and the Children's Solicitor prepared a position statement. I hope you've had the opportunity to consider that.
Yes,
I'm sorry it's rather lengthy. The reason particularly for that was that I wanted the court to be aware that Ms Linden wrote to the court on the 2nd of February, really out of a sense of growing frustration as to the way in which the local authority appeared to be formulating their plans for these children. Because what effectively happened was the original care plans were filed, which effectively recommended that the children would remain living with their mother, not obviously in Mr. Howson's home, but would remain living with their mother, as we've already heard, with no public law framework around that. And supervised contact, supervised by the mother. On the back of that care plan, quite properly, given that we have two girls aged 14 and 13, the children's solicitor and the guardian went to visit them to ascertain their wishes and feelings, and indeed to look at the potential for separate representation. The girls were very clear that they did not approve of that plan. They wished to return to their father's care. They understood their father to be well now, and therefore they couldn't understand why they couldn't go home to live with their father. They were not prepared to canvass or really consider any arrangement whereby they would be split from their younger brother Harry. The solicitor, Ms Linden, was then giving active consideration to the need potentially for separate representation. This was on the back of the local authority's full assessment that did not recommend the children having any unsupervised contact or any care from their father. Within a matter of days, there was this strange communication that seemed to take place with certain people and not other people, the outcome of which seemed to be that the girls became aware that in fact the care plan was going to change, and in fact they were going to get their wish, which was to return to the care of their father, but that young Harry would stay with Mum. They were very pleased that they were going to go back to Dad, but they didn't want to be separated from their brother. And the mother didn't appear to know any of this and appeared to have been told by one of the children one evening after school that in fact they were going back to Dad now. That caused the mother some difficulty because of course she'd then given notice in her work, and as you've heard from Miss McNally, she's in some difficulties with her housing. All this left the Guardian asking questions which were not answered, either through conversations that she was having with the social workers on the ground or that Miss Linden was trying to achieve through communication electronically with the local authority. Hence, writing to the court, saying the Guardian wouldn't be ready. That's the letter I've actually just
reproduced in your
yes.
Yes.
Because the Guardian couldn't file on time. We've now been provided today with care plans that appear to go back to what was the original, but with two material differences. One, there's going to be a public law order, and two, there's going to be unsupervised contact for 2 out of the 3 children. The Guardian, as we stand here now, doesn't understand, we've not been able to read or understand, and perhaps we will tomorrow when we get the statement, how the local authority have reached the conclusion that the contact can now be unsupervised. So where's the risk assessment in respect of that? Because of course the only document we've got is the local authority's full assessment that in fact talks about a high level of risk. So that, we need to understand that. However, what is of much more importance is that the Guardian, I suppose, is hearing today through those representing the parents, what the parents' views are about that care plan. Mrs Devlin would want the opportunity to go and sit down with the parents, as she has done, talk to them about the new care plans, get an understanding of what their views are about that. Then having that, because we're talking about girls aged 14 and 13, being able to then go with Miss Linden and sit down with the girls and talk to them about the care plans that we now actually have effectively in black and white. We, the 3 of us, anticipate that there will then be an issue about separate representation, particularly given that the girls became aware that the plan had gone from Mum to Dad back to Mum, and are frankly very disappointed. So it's entirely likely that they're going to require separate representation from the Children's Guardian, which we've got very little time to facilitate and organise and file a report. There's only effectively 2 weeks, less 1 day, before we have the final hearing. And Your Honour may appreciate, although perhaps it has got slightly lost in the midst of this hearing, the girls want to speak to the court, they want to speak to the judge, and I know that we were going to...
That's a separate issue entirely.
It is. But it's the
I
timing
can
of
immediately
that.
think of all manner of reasons, based on what I've heard this morning, why that would not be a sensible idea in a case as fraught as this one.
Quite, and we may have
I
to
understand.
revisit that
Yes,
with them.
always extremely happy to meet children, particularly children of the age of Stephanie and Katie, when I've made my decision to give judgment, for purposes of explaining judgments, particularly if they are judgments that the children don't agree with. But as I understand the latest pilot this care centre has agreed to undertake, the purpose of the children coming to see the judge is not to say anything that may affect the judge's decision. It's simply to give the children some sense that they are involved in the case. But I think the prospect of me meeting Stephanie and Katie and them resisting the temptation to say things which I simply couldn't ignore in the decision-making process, and it's bound to come out. And without some guidance as to what I'm meant to do about that, particularly when they're separate representative, as I will be sure they are if they strongly object to the plan, it's difficult.
Yes, and I think, Your Honour, the point at which there was some consideration of them coming to see you, and I know that Your Honour said that you were more than happy to have that happen. Of course, that was before we've had all of this unravel, and at the moment, I know that that's something that Mrs. Devlin particularly and the children's solicitor want to talk to them about, but they've resisted quite properly going to see these girls until they've actually got something in writing from the local authority and their parents to discuss with them. Because they had arranged to see the girls on Friday of last week, but because the planning seemed to be so confused, in fact, we took a collective decision to not see them until we knew where we were today.
Well, I'm sorry, but the more I hear about the case, the more I see this as a conflicting case. If it ends up with Stephanie and Katie being separately represented, I can't think of any better way of having them closely involved in the case than that. But my personal view is that the pilot has not been sufficiently thought through as to what the judge's role is in a case as difficult as this, because if there's no clear guidance as to what status anything the child says to the judge actually has in the decision-making process, I'm reluctant to speak to children until it's all over and I can explain what I've done.
Yes, absolutely, and I'm sure that Mrs. Devlin and Ms. Linden will appreciate that. We can talk about how that then can be communicated to the girls. The most important thing now is for the guardian to have sufficient time and opportunity to consider those care plans, ask any questions that she has arising out of them, particularly in respect of how this unsupervised contact and this shared care arrangement will come into being. We haven't looked at that and seen what that says. Have a look at the analytical statement, see what mum and dad have got to say, and then effectively take all that and go and sit down and talk with these girls in particular. It's whether that can be done in a week, effectively, and 2 days.
What are you taking a view that it can't?
I struggle to see how it can, I have to say, and to do it properly.
That was the 26 weeks, so it's time.
Well, I think
23rd of March.
yeah. It's not said lightly, because these children want resolution. They want to know what's happening to them, particularly the older girls do, and indeed their parents do. But I think the guardian had had this hope that, had it been managed in a much more productive way, I think she felt quite confident that she could sit down with these parents and have a dialogue as to how they arrange the future for their children. But the difficulty with that, particularly if we have contentious litigation, which on the face of it we now have, that slips away. And I think it's with great reservation that I have to stand here and say that it's difficult to see how we can embark on this. My anxiety is that we will embark, that if we do embark on it, we're just going to fall at the, we're going to fall
We
at
run into a
the,
cul-de-sac.
we do.
Thank you. Well, I'll treat that as application the court to take an option of last resort by adjourning the final hearing. Does any applicant want to oppose it? Have I read somewhere that someone's suggesting that one of the days
Yes, I would.
when the case is currently listed for final hearing be taken up with an adjourned issue resolution?
Yes, I wonder if we can at least productively use, maybe even the first 2 days, the Monday and the Tuesday. I don't know whether, you know, that affects the court's diary, but if we could literally have that opportunity, when everybody's seeing everything that's been filed, and the guardian and the children's solicitor will have used the time to go and talk to the girls, and if we can get some representation for them. I'm not saying that we can resolve this case. I'm not saying that that will be the
Saying it's a
outcome.
good prospect.
But the Guardian still has hope that there might be some prospects for salvage. If maybe we use a couple of days in that week, if there are contentious issues, they're not going to be able to be resolved. But I think it's just an aspiration to try and use something that week.
Is the Guardian in favour of the supervision?
Yes, I don't, but that's not a difficulty. I know the Guardian was anxious about there being no public law order and leaving the mother effectively rudderless.
If
So,
you've
yes.
said this and I've not picked up on it, it's my fault, but have I heard from you what the Guardian's view is on the objective assessment of the best interests of the children, as between living with their mother and living with their father?
You haven't, and the reason I'm hesitant about that is that really what the Guardian had, her hope had been, and again it's something that she's going to want to develop with the parents and girls over the next few weeks. She had hoped that they might be able to, as parents, reach a resolution about what was best in terms of their arrangements for their children, rather than it being simply, well, they're living with you, they're only seeing you. I think she had seen it more as a way of negotiating seems the wrong word, but yes, negotiation was the wrong word. But, you know, and she had felt hopeful for that. But on the other hand, of course, the Guardians understood very clearly both parents' frustrations, which were then translated, which they are, as Your Honour knows, to girls who are 14 and 13 who know what's going on and have their allegiances and their loyalties.
This is very sound common sense, if I may say so. That's what one expects from the Guardian, who is independent of the parties and take an objective, fair-minded view. God bless you in this case, then. Great happiness about it is this is a public law case, but nobody's saying the children need to be removed from their family. It's not really the element of the private law case in which the court, if it has to, and I hope it doesn't, has to choose between care by mother or care by father. And that's always best sorted out by compromise between two loving parents. That's the Guardian's position
It is.
today.
It is.
Ask wherever they live, they're going to need to see a lot of the other parent.
Absolutely. Because these children have, in living with their mother, they have established a very good relationship with them and a very good attachment to them. And it's about balancing that. And their overwhelming love for their father.
Yeah.
And the Guardian is still hopeful, even now, of trying to make something work.
Right. Well, I'm indebted to all the applicants who addressed me about their respective positions, but I'm particularly indebted to the Guardian, who as Guard was persuaded me that there is some prospect of finding a resolution for these children, which makes their parties and the children themselves, who understandably want to be involved, in the agony of conflict. The court case. So, nobody actually opposing what is in effect an application by the Guardian to adjourn the final hearing, but to keep the case in the list for up to 2 days to see whether middle ground, sensible middle ground for the benefit of the children can be achieved. Well, I'm prepared to adjourn your application and treat putting on evidence. Still given an IRA 2 days, but I'm prepared to treat day 1 and day 2 as issue resolution. Be available at all times to hear submissions and, if necessary, some brief evidence to see whether we can resolve the case.
I just wonder, Your Honour, given that, as I understand it, the case had remained in the list for 4 days, the Monday through Thursday of the week of the 23rd, whether keeping the Wednesday and Thursday, the latter 2 days, does allow extra time for the various discussions that the Guardian has outlined needs to take place, buys 2 extra days. It's no more than a suggestion. I realise that the local authority is entirely in the hands of the court of the others, given its part in what has happened today. I'll make that suggestion.
Wednesday, Thursday.
Yeah.
And I think it concentrates people's minds if we
Keep it on
keep it on a Monday.
Very well.
It must all be available for Monday, Tuesday,
Quite.
because
Yeah.
it's currently in the electronic diary, 4 days, starting on Monday.
Yeah.
23rd.
It is, Your Honour, yeah.
The only invitation is time for parents to respond to statements. We just understand additional time parents should reflect and, of course, read difficulties we might give the plan. I appreciate capacity, but it doesn't matter. It might assist with the overriding fair.
Are you getting what is coming now from the local authority by 4 o'clock today?
Tomorrow, Your Honour.
Was the timetable already placed for the final evidence? Darren?
It does, but would be on those dates, Your Honour, because the local authority didn't comply with its own dates.
I don't think I'm inclined to put any obligation on the parents to file any discards, advocating strongly the role of talking on reading.
Yes, I think the Guardian's time is best used now, going and sitting down and talking with Mum and Dad and the girls, particularly.
Yes, I agree.
And we can everyone can file position statements on the Friday before we
Position
return.
That's
Before we return to
2
see
sides of
you,
it. That's right.
Yeah.
Distribution.
and we can come and see you.
Yeah.
Perhaps maybe 2 o'clock on that Monday and have an advocates meeting in the morning.
Well, that's truly important. Very generous offer by the Guardian to do this mediation. I take it Mr. House is prepared to talk to the Guardian.
I have done, yeah.
Good. All the lawyers do far too much reading in these cases, not enough listening. I mean, the judge essentially. And I just wish in more cases the parties could do more talking than writing. Now, that's a good way forward, I think.
Certainly is. And listening,
This might not even feel time sitting there.
understand and lying.
A very experienced guardian who's got the best
Understood.
interests of the children at heart, so what she's got to say is great of you. And open up the way as litigation, because the fallout from answer 2. who would benefit greatly from getting some news that their mother and father are agreeing things. It's always joyous for children to know that mother and father, although living separately, can agree important things about. So I
Well
see the
done.
case. You're going to draw all this in an order, are you, Mr. Brown?
Yes, Your Honour, can I just be clear about what is being directed then? So the local authorities statements will be 4 p.m. tomorrow, an adjourned IRA on the 23rd and the 24th of February, an advocates meeting on the morning of the 23rd of February, so listed not before 2 o'clock for Your Honour on the 23rd.
I'll be here. Are you
Well,
going
I
to be in the
should be-
building?
Yes. Yes, well, I've simply listed on those 2 days, and then position statements by 4 p.m. on the preceding Friday.
Well, let's do it at 10:30.
Yes,
I love the 23rd.
I will do.
I'll be working in my room and I can see you anytime.
Is Your Honour content for me to send in that order electronically today? Or
Yes,
do you-
so,
I'm grateful.
all right. So we next see each other on Monday the 23rd. Okay.
Your Honour, yes.
Thank you very much.
All right.
Okay. I'll sign it tomorrow.